for trial on Clay versus Park Estates. Mr. Clay, you ready to roll?
Yes.
All right, counsel, your appearance for Park.
Seven, turning on the gas.
Okay. Let's get started. Any opening statement, or you just want to jump into testimony? Yeah, go ahead.
I took over that trailer. My mother passed away on 5/8/24, and my brother was evicted on 10/23 of 24. And I sold that trailer to a guy that backed out of the deal, started suing me too. I don't know if you recall that.
No, I don't.
But we didn't lost. But I tried to sell it again, and the park manager refused to let me sell my trailer because he said that other guy had any lawsuit against me. And so I went to trial for hearing, and he never showed up. I got dismissed, and I took the dismissal to the park manager and said, "Now I can sell my trailer." So I went to the second hearing to be filed, and he didn't show up at court again. And I took the second dismissal. He said it didn't check with his legal department, and he still didn't sell for them. And then I talked to the manager that she's above the park manager, operations manager, or district manager. And she said, "Well, you didn't sell your trailer. We don't." But after they said yes, they said I owe $7,500. I could have sold it that month of November. The other guy backed out on the 31st of October, and I got plenty of people.
Okay, let me stop you, because this sounds like you're telling me your whole case in testimony. All right, well, you understand nothing you're saying right now is going to be used in my decision making because it's not evidence. It's just an opening statement. Okay, all right. Anything else is by way of opening? Okay. Opening or reserve? Go ahead.
This is a case where the goalposts have been constantly moved. Mr. Clay filed an amended complaint April 29th of this year. We had at least one pretrial subsequent to that date. And at that time, I explicitly asked Mr. Clay whether he was going to stick with the allegations in the April 29th suit. Because those allegations superseded basically everything that he's just stated. The original lawsuit involved alleged interference with his right to sell the trailer. Claim delivery case has nothing to do with that. And Mr. Clay explicitly indicated that this was what he was going to rely on.
Just to make sure in my memory, the amended complaint took it to a claim and delivery, correct? Okay, go ahead.
So anything above and beyond the allegations in the complaint, I would argue are irrelevant for this trial based on the acknowledgement Mr. Clay made in the pre-trial. Further, Your Honor, the eviction itself was completely proper. Pursuant to case number 24-6294 LT, which you also presided, a judgment of possession was entered in that case in favor of my client and against Mark Clay, who actually gave permission for his name to be signed. It was a consent judgment. That required all rent to be brought current by September 27, 2024. When the rent was not brought current, an order of eviction was submitted, which you entered on October 7, 2024. The eviction was then carried out. Now, the claim and delivery complaint claims damages for basically, I guess, the wrongful taking of certain property pursuant to the order of eviction. I would argue that Michigan case law is very clear and Michigan statutory authority is very clear that my client is immune from any damages because the items that were removed pursuant to the law of the issue.
Okay. All right. Thank you. All right. Ready to present your case? Okay. Do you have any witnesses or are you going to testify?
Yes.
Okay. Counsel, are you all right if he just stays where he's at after I swear him in? Are you okay if he stays there to testify instead? Yeah, and you'll let me know if you're not picking him up. He seems to be loud. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today? All right. So give me your testimony.
Well, testimony is I took over the trailer from me and bank on the pathways.
But let's get to the point where you file a claim and delivery saying that they owe you money for property. So let's get to that.
I sold it. at some law firm that helps people.
Okay,
He told me about the claim and delivery, I had no idea about that.
okay,
And, they took my property from my trailer, they had no right to enter my trailer under Michigan law, I guess the way it is. Says they cannot damage the property, your property stays yours, if they say they did it under Michigan law, they didn't do it under Michigan, mobile home law. It says they cannot damage my property or take my property. Maybe later, when, different costs occurred, I could have had it all paid up. They just let me sell my trailer, and this would have been done long ago.
okay, so what property was damaged?
Fishing tackle line, my company, they loaded everything in the trailer. Into 3 trailers, in my mobile home, in the 3 trailers that was hooked into the landfill. On the 23rd of October of 2024. And they had no right to enter my trailer. They had the right to evict my brother. And, but they didn't have no right to take his property or my property because that's my trailer. That, they say that you signed an order saying they can do that, but I don't see how you can really do that.
I didn't sign an order that said they could take personal property out of the trailer and put it to the dump.
But that's what they said in a little meeting we had. The judge signed the order such that. I don't think that unless they put a fraud on the court saying that it was their trailer or something. But, yeah, that's my case about my claim and
Okay, okay, but you understand with the claim and delivery, you have to establish value of the property and exactly what the property is and so on and so forth. Because a claim and delivery is saying, Judge, I want my stuff or I want the value for my stuff.
I got it in my filing.
In your what? I'm sorry? Your filing is not evidence. Your filing is not evidence. I make decisions at trial based on evidence. So you have to present the evidence today if you want me to consider that in my judgment. You understand what I'm saying?
I mean, but I can.
I don't know what to tell you. You've chosen to get into this arena without counsel. It's not fair for me to try your case for you and leave him to defend himself or his company. I can't help you present your case. All right. So I'm going on a limb when I tell you what you're supposed to be doing right now is establishing the items and the value for those items if you want me to give you a judgment of money for the missing items.
All right, well, I have some tools. I mean, do you want it written down? How would you like this?
Once again, I can't tell you how to present your case to me.
I have some tools that were missing, that were taken out of my shed and my home. I valued them at about $7,500. It was taken. And they took my dad's flag, his military flag, which I considered out the price that was in a box in the house. And they took about I put it down $10,000. They took about $30,000 fishing tackle, but I used to be on
Well, my limit is $25,000.
Yeah.
Right.
And then they took some furniture, couch, and clothing. That's what I put down there as the amount. I know.
Okay, but once again, your filings aren't part of today's record at trial. So you keep saying, I put it down there, I put it down there. You've got to talk about it today as sworn testimony.
$3,000 worth of small appliances they took out. And probably about $1,000 worth of clothes. And my dad's flag and some living furniture, which was about $1,200, I can say. That's my personal property.
All right, anything else at this time?
I would just like to say that I don't feel they filed a claim against me for the rent. I don't feel
Let me stop you. That's not up today, is it? Did you counterclaim for rent? Okay. All right. Go ahead.
Okay, once the manager told me I didn't sell my trailer, I just figured the rent wasn't due. I never got a bill on that rent. And I still haven't got a bill for rent. Anything. Like I said, it just kept adding up. They never sent me any kind of invoice. They never signed anything with the park saying I had to pay the rent. I just wanted to sell my trailer and get out of the deal. That's all I wanted to do.
Did you ever sign any kind of lease with them? Anything else?
I got my witnesses.
Okay, well, once again, it's your case to present. You decide how to present your witnesses. Come on up, sir. No, hold on. Stay where you're at. Would you like to cross-examine this, Mr. Clay? Go ahead.
Have any documentation with you today of the values of these items that you claim?
No, I didn't.
You have no independent verification. Okay. So basically, the court simply had to take your word for it as found as far as valuation.
Just,
Okay. The fishing example, when did you buy it?
I started fishing in, a lot of the old stuff, early as 1990 up until, 2010.
So you used it obviously often during that period of time.
Yes.
So it's appreciated, correct?
I don't think so.
You're guessing that it didn't. The tools also were used.
Yes.
Okay, so again, could have appreciated. Your dad's flag, is your dad still alive?
No.
Okay. Was there a probate estate?
Open. I know,
Were you ever appointed personal representative of the estate?
yes. Well, my mother,
Your mother. Okay, so your mother would be entitled to act under the estate.
my mother was dead on the flag disappeared, so then it was mine.
All right, did you open a probate estate for your mother?
No.
Okay, so there's no court order that permitted you to act on behalf of your mother's estate or your father's estate.
So I inherited all my stuff from my mother, so I guess the flag is mine.
Couch, clothing, again, depreciate, all used.
Yes.
All right. And small appliances used, clothing used.
Yes.
All right. And you don't have any valuations today of any of these items.
No.
Okay, including or not including depreciation.
Right.
You do not dispute that a judgment of possession was entered by Judge Oakley against your brother on September 13th, 2024.
I don't know what day it was. It was one around there.
No. Go ahead and get that. Mark this an exhibit. I'm not giving that. Oh.
Heather.
You will copy the document, not the defendant's proposed exhibit 1, and ask you if that is, to the best of your knowledge, the judgment of possession was entered in the case against your brother.
Yes. That's
And, okay, and it was approved by Judge Oakley, if you look at it, September 13th, 2024.
Yes.
And it provides that the sum of $1,491.46 has to be paid by September 27th. Is that correct?
Yes.
That's paragraph 4 is. And if it's not paid, then my client would have the right to apply for an order to evict your brother's.
Yes.
Okay. Now, was that going to be paid by September 27th? When it was been marked, or was going to be marked as defendant's proposed exhibit 2, and ask if you can identify.
What was that?
All right. I'm going to give you what's been marked as defendant's proposed exhibit 2, correct?
Yes. Yes.
All right, and that is an order of eviction that was approved also by Judge Oakley, correct?
Yes.
And that order of eviction provides that my client is entitled to be brought to immediate possession of the premises, correct?
The property.
Immediate possession
Of the property.
Yeah. So based on what you were told by an attorney whose name you disclosed, it is your belief that my clients do not have the right to remove anything from that trailer. That's correct.
I'll take judicial notice of that fact.
State law that says otherwise.
I'd like to see it. Trailer wasn't yours.
I will, I'm glad to go copy of it.
Love to see it.
So, I guess the question that I have for you, well, I won't even ask it because the case law speaks for itself and all lawyers they belong. The order of eviction was carried out, correct? Yes. A court officer pursuant to the order of eviction. Yes. That's it is not representatives of Park Estates that came in. Well, they court officer. Court officer.
Court officer works for the plaintiff in an eviction counsel. You know that.
Well, but the order of eviction instructs the court officer to restore the plaintiff's possession.
Of the lot. Of the lot.
I'll respectfully disagree with the court based on the case law that I think we have.
Okay.
Now, your brother signed the lease for a lot.
Yeah.
You know, so. So it's your testimony that nobody signed the lease for a lot?
My dad signed an application for when the other company was the owner of the trailer park. I don't know if I recall the name,
But your brother signed the judgment. Approved the judgment for entry, correct?
for the eviction.
Yeah.
Yeah, I guess, okay. I was there. Was your brother living there?
Yes.
He was.
And this was not the first case that was brought against him for eviction, correct?
I believe it was.
There was not another case that was filed in April of 2024.
That's what I know.
I nothing further on.
Okay. Okay, so I'm gonna take that. You testified as direct. This was crossed. Do you have anything now under redirect, or you want to put your brother on the stand? Come on up, Mr. Clay. The other Mr. Clay. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Come on up here and have a seat. Your first name is Mark?
Right here.
Yeah, right there. Settle in that chair. All right. Plaintiff, Mr. Clay, you can ask questions of witness, Mr. Clay. Go ahead.
The first week of November, seventh grade, I don't recall the date. Did I ask you to come in and listen to a phone call between me and Eddie?
Yes, you did.
And you recall what Eddie said?
You can actually look at it because it was under oral support. It was something to do with the
lawsuit.
Your Honor, I'll object on the basis of relevance. Once again, this has nothing to do with the plaintiff delivery. It has to do with the original complaint that Mr. Clay filed, which was superseded by his own admission.
So claim and delivery is you're saying they took your stuff, you want your stuff back. If they can't give you your stuff, you want the value for the stuff. So how was that phone call? Who's Dave, by the way?
Yeah.
All right. How is the phone call between you and Dave relevant to that? Okay, move on.
Did the court officers empty our trailer?
yes, they did.
Everything.
Everything.
And the shed. That gave an accurate description of our property.
Yes, very good. Yes.
You lost property.
I lost about $40,000 myself.
And are you gonna file a lawsuit?
Yeah.
That's all I have in this information.
That's
Hold on. There's no question, no answer. Cross.
Mr. Clay, you approved the entry of the judgment of possession. That was exhibit 1. Show it to me.
I don't know,
So yes or no question? Yes. And you didn't pay the rent.
Correct.
Yeah. And therefore, there was an order of eviction that was issued by the court and carried out.
Yes.
Nothing further.
Okay, any redirect of Mark?
Well, did you feel he was under arrest by, you had to let them people in?
Yes.
So you're.
Any recross?
There was a court order that handed down to effectuate the eviction. True?
Yeah, Your Honor.
What's your objection?
What's that?
What's your objection?
Well, he's stating, court order said they can enter. Basically, what he said, he's gonna show us the case law. We ain't seen that yet, so I don't think that's any proper question.
I think to put it in legal terminology, that would be lack of foundation.
I'm not sure necessarily law has a lack of foundation, but let me see if I can establish. Mr. Clay, there was a judgment entered, you didn't pay the judgment, correct?
Correct.
And the judgment provided that Park Estates would request and have issued an order